Trade secret laws can limit competition and restrict employee mobility, making them a means to carve out a market space. However, trade secrets cases may also be brought involving benign information that's really difficult to classify as a trade secret, and it's more for competitive reasons. So the first issue in the defense of any claim for misappropriation of a trade secret is going to be to determine if there really is a trade secret at issue. My name's Jay McDaniel, and you are listening to Closely Held. If you have questions on the subject matter of a trade secret or a matter of your own that you need to discuss, feel free to reach out to us. The first step in the defense of a trade secret case is to examine whether there is real value in the information that's claimed to be secret. The touchstone of a trade secret is that it provides the owner of the information with a competitive advantage in their market. Courts look at the cost of development, the difficulty in duplication, and the measurable benefits to the owner to ascertain whether there's a bona fide trade secret in play. Today, trade secrets are brought primarily under the provisions of the Federal Defend Trade Secrets Act, the DTSA, as they say, or the Uniform Trade Secrets Act, the UTSA. The Uniform Trade Secrets Act is a uniform law that's been adopted by the legislatures in most states, and we're going to focus on that here. The UTSA provides a simple definition of what is a trade secret and what constitutes misappropriation. As to what's a trade secret, there are basically two elements. The first is that the information derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other people, and for which the owner can obtain economic value from the fact that it's not known, that it is a secret. The second element in a trade secret is that it is information that the owner takes measures that are reasonable under the circumstances to maintain its secrecy. Our focus today is really on the first element. Is the information proprietary? In other words, does it have real commercial value to the owner? And does the owner depend on secrecy to protect that information from use by others? Determining whether a company derives independent economic value generally is done on a case-by-case basis. And the factors that you may need to include in this consideration are the competitive advantage from the trade secret, the effort and cost to develop the information claimed as a trade secret, the potential or actual profitability that arises from the use of the proprietary information, whether reverse engineering using legal means is difficult, whether knowledge of the trade secret is limited. In one well-known case, the court said that the key to a trade secret is that the information provides a company with a substantial commercial advantage. It needed that to qualify as a trade secret, and the court was careful to distinguish that common business practices and knowledge do not meet the standard because they don't provide a significant advantage over competitors. So, in other words, does secrecy over this information translate into profits that are not seen by others? That seems to me to be the key. Is it difficult to reverse or engineer the product? If the information cannot be readily duplicated, it's more likely to have independent commercial value that makes it a trade secret. Is knowledge of the trade secret limited? If the information is only known within the company, is it available only on a need-to-know basis within the company? Competitive information is guarded by its owners, inside and outside the business. The way company processes information internally may speak directly to its value. A company that requires its employees to sign non-disclosure agreements likely believe the information has independent commercial value. Some of the cases that we've seen in the office that really involve questionable claims of trade secret misappropriation seem to be more about using the statute as a hammer to prevent competition, included generic marketing plans, customer lists that were available to everybody in the business, or information that was compiled from public sources. These types of cases need to be compared to those that may involve processes or data that truly are competitive and secret. Thanks a lot for listening today. I hope you found the information useful. If you did, feel free to share it, and you can reach us through the contact information that's below this video. Thanks again for listening.